May it please the court, my name is Peralta initial P, and I'm appearing on behalf of Mr. Selders, a 14-year-old Torres Strait Islander boy charged with 9 counts of burglary and 4 counts of stealing. Pursuant to Section 590 A of the Criminal Code Queensland, the defence seeks that the court exercises its discretion to exclude the Crown's evidence relating to my client's oral and recorded confessions. Your Honour, Section 130 of the Queensland Evidence Act, QEA, preserves the common law discretionary powers to exclude evidence. While the defence concedes that the evidence in question is prima facie admissible, it submitted that the Crown's evidence should nonetheless be excluded on 2 grounds. Firstly, on the basis of the fairness discretion, or alternately on the basis of the public policy discretion. Firstly, Your Honour, the defence submits that the fairness discretion should be exercised to exclude the Crown's evidence. Established in the case of Christie and adopted into Australian law by Lee and Hassler, the fairness discretion calls on the court to exclude evidence where its probative value is substantially outweighed by the prejudicial effect that it would likely have on the jury. When considering the probative value, we must look to the relevance and reliability of the Crown's evidence. While the admissions made are clearly relevant, there is serious doubt over the reliability of the evidence, given the pervasive presence of gratuitous concurrence apparent in my client's admissions. Gratuitous concurrence is when an Indigenous person is faced with a white authority and subsequently agrees to every proposition put to them due to unfamiliarity, intimidation, or to indicate respect. Your Honour, there were 2 significant instances of gratuitous concurrence. Firstly, my client's oral confession in the police car relied solely on his accurate identification of 8 houses and subsequent admission of guilt. My client agreed to these accusations put to him by police, despite the fact that he was looking down at his hands for the duration of the car ride. The defence submits that when answering the police's questions in the affirmative, my client was attempting to appease the older white male authority, and therefore gratuitous concurrence was at play. Secondly, my client was placed in a room with an older white female social worker and instructed by her to ensure he answered the questions from the police. In the recorded interview, my client was placed in an intimidating situation with 2 white authorities and abided by the direct instructions given to him by the social worker to avoid disrespecting his superiors. Your Honour, if these admissions were presented to the jury, it would undoubtedly weigh significantly on their minds and prejudice the ultimate decision. Given the gratuitous concurrence evident, the defence submits that the Crown's evidence has an extremely low probative value, high prejudicial effect, and as such should be excluded on the basis that it would be unfair to the accused to admit this evidence. Your Honour, now turning to the public policy discretion. Originating from the case of Ireland and expanded in Bunning and Cross, the discretion seeks to preserve public's confidence in the justice system by excluding evidence if obtained in an unlawful or improper manner. In this case, the police breached a number of significant obligations under the Police Powers and Responsibilities Act, PPRA. Each will be addressed briefly and then applied to the Bunning and Cross case. Section 418 of the PPRA states that prior to questioning a person, the police officer must inform them of their right to telephone a friend, relative, or lawyer and delay questioning to allow this to occur. Failure to inform my client of these rights was a clear breach of police duties under Section 418 and subsequently deprived my client of additional rights under Section 419 to have a friend, relative, or lawyer present during questioning. Under Section 420 of the PPRA, police officers must allow a child to speak to a support person that's been chosen by the child and have them present during questioning. Although a social worker was present, my client did not choose this support person as the decision was made by the police officer in direct contradiction of the PPRA. Your Honour, the defence submits that as my client is both a 14-year-old child and Torres Strait Islander individual, he should have been afforded the additional rights under Section 420 of the PPRA to have a legal aid representative notified of his arrest. While Section 420 refers specifically to Indigenous adults, it's open for the court to conclude that given my client's significant vulnerability, an additional level of care should have been afforded, and the protections from both Section 420 and 421 should apply. In failing to notify a legal aid representative, the police breached these additional duties under Section 420. Failure to caution my client in relation to his choice to speak freely or remain silent also breached Section 431 of the PPRA. In Bunning and Cross, the court articulated 5 factors when applying the public policy discretion. In this case, the police officers demonstrated a flagrant disregard of their duties under the PPRA, which at the very least was reckless, if not a deliberate breach of the law. While the defense acknowledges the cogency of the evidence, gratuitous concurrence was pervasive throughout the admission process, and therefore the evidence holds extremely low probative value to the case. The officer's conduct was not a response to any pressing circumstances, and my client was not charged with a highly serious offence. Your Honour, the purpose of the PPRA is to prevent the exact conduct demonstrated by the police. On the balance of factors from Bunning and Cross, the defence submits that the evidence be excluded on the grounds of public policy, given it was obtained in an unlawful and improper manner. Your Honour, throughout the process of my client's arrest, questioning and confession, the police officers blatantly ignored fundamental responsibilities when dealing with my client, a vulnerable person. The defence submits that the evidence in question be excluded in accordance with Section 130 QEA on the basis that its admissions would be unfair to the accused and would ultimately negate the sanctity of the judicial system.